My name is Umar Clark, founder of the Bureau Bullies. I've been in the credit space for well over 10 years now. Through multiple failures, I've learned how to beat these companies at their own game.
And then we're going to put together an action plan.
We built this platform to empower consumers to fight back against inaccurate credit reporting, abusive collections, and a system that depends on you not knowing your rights. Through education, strategy, and consumer law awareness, we've helped consumers remove millions of dollars worth of debt from their credit reports, and we've shown everyday working class people how to sue and win without an attorney. Our slogan is simple: sue them all. From the United States to communities around the world, the Bureau Bullies is here to help consumers stop being afraid, start understanding their rights, and take their power back.
Welcome to another episode of the Bureau Bullies, aka the Sue Them All podcast. Today we'll be going over late payments. I know this is something that a lot of people are going through, and what I want to make clear is that this applies to everybody, because normally what happens is when we gonna come on here with specific topics, people are like, hey, well, this does apply to this company, that company. This applies to any furnisher that's on any credit report that's reported a late payment on your report. All right, so the flow of this is going to go, number one, we're going to actually go through what late payments are, because there's a lot of misinformation on the internet about what they are. We're going to look at the effect of them on your credit report, how they specifically affect your credit report and what it may be hindering you from getting. And then we're going to put together an action plan. But a quick disclaimer, I must be clear that we don't promise any results based on any information we put in our videos, in our ebooks, etc. And also, I am not an attorney, so if you need legal advice, please seek advice from a qualified attorney in your state. All right, with that being said, let's get into it. So I have notes here because if you've been a Bureau Bully fans for a while, you notice one of my biggest issues is I start to ramble, and I'm going to do better with that. So I said, for now on, when I shoot YouTube videos, I'm going to keep my notes in front of me so I stay on topic. All right. Number one, a late payment by definition, if you actually look under the FCRA, it doesn't define what a late payment is. This is an internal thing that goes on between you and the furnisher that you're doing business with. So this is your American Express, Discover, Capital One. This is an internal thing. And because it's an internal thing, it's judged by your agreement first, then it's judged by what's reported to the CRA. So make sure you make note of that. Now, the thing about a late payment is it makes up 35% of your FICO score, right? So that's the biggest factor. And that's a very huge chunk. That's close to 50%. We're 15% away from being 50%. So 35% is a very high number. So one late payment, a person, which I've seen this personally, a person can have almost an 850 credit score, and they could be traveling or something, and they get one late payment and it drops their score over 150 points. Now, I know you're saying, oh, somebody goes from 850 to 700, it's not a big deal. No, that's a huge deal. All right. Now, something else I want to add before I go deeper into this is I do not believe in goodwill letters. Don't believe in them. If there's a late payment on your report, we're going to fight to no end, but we will never do a goodwill letter, and here's why. When you do a goodwill letter, you're at the furnisher, aka the creditor's complete discretion. So if they feel like removing it, they will. And if they don't want to do it, they won't. Now, when they say they won't, and then you try to apply some of the methods I'm going to teach, they're going to use that goodwill letter as leverage because they keep a record of everything you send them. Late payments take account for 35% of your score. And the thing is, one single 30-day late payment is reported for 7 years. So one little mishap is going to haunt you for the next 7 years. Now, the thing is, if you just have one late payment, I'm saying it lasts 7 years, but it has less of an effect on your credit score over time, but it still does affect it. So the newer it is, the bigger the effect that it has on your credit score, right? And the bigger your credit score, meaning the closer you are to that 850, the harder the late payment hits. All right. But what you have to understand is that something being reported doesn't automatically make it accurate. And the reality is, under the FCRA, accuracy is the law, not what's reported. So you'll talk to a lot of these creditors, Wells Fargo, etc. They'll say, well, we have to report it. That's not totally true. No, they have to be accurate. There are 5 segments we're going to look at. 1, how late payments really work. 2, Metro 2. This is the hidden language of your credit report that most people don't know. Number 3, your FCRA dispute rights. Number 4, we're going to actually look at penalties with real teeth. And number 5, I'm going to give you a playbook. So here's number 1, how late payments really work. Late payments, right? A late payment isn't late to the CRAs until it's 30 days past due. I'm going to say it again. A late payment is not late to the CRAs as Experian, TransUnion, and Equifax until it's exactly 30 days past due. So if you miss your due dates by a few days, right? Creditors, if your payment was due on the 5th of March, you didn't pay until the 4th of April, that's not 30 days late. And it can't be reported as 30 days late. And that's what happens to a lot of people. Remember, it's not based on what's verified, it's based on what's accurate. All right. So creditors, they generally report a missed payment to the bureaus only once it is at least 30 days past the due date, right? So if you paid before it was 30 days late and it still hits your report, which it always does, that's a violation. Now, you'll still owe a late fee, but that doesn't automatically mean you were late. According to Metro 2 compliance, you have a 30-day late. You have to make sure you're exactly 30. Then you have a 60-day late, then it has to go all the way up until whatever. Now, this is an internal thing again, when it officially charges off, etc. But today we're not talking about charge-offs. But now you have to first make sure you were actually 30 days late on the first time they mark you 30, because what happens is they mark you 30, that's been re-aged if it wasn't exactly 30 days, and then they'll start adding 60, and each one becomes an even bigger violation. But each one is hitting your report harder and harder. So your first step before you start any action plan is to make sure you are actually 30 days late. All right. So secondly, how much does each late payment cost you? Now, the first late payment on an excellent profile, which in my opinion is 720 and above, it hits you way worse than a person with a lower profile. So anybody under 700 is not going to get hit as hard as somebody over 720 when it comes to a late payment. That first late payment normally can drop you 60 to 110 points. But after that, it slowly starts to fade as your score drops. So if somebody has a 500 credit score and they get a 30-day late, it might not even move, maybe 5 to 10 points. But somebody over that, they're going to see a huge drop. So the more, the way it's phrased or it looks, the more financially responsible you were, you're penalized even harder, right? When you have one mishap or have one mistake. So I had a client one time who always maintained good records, always had a great credit score, etc. And they literally forgot about one of their mortgage payments because they were in real estate. And when it hit, it dropped them astronomically. And before they came to us, they reached out to the creditor to attempt to make a goodwill adjustment. You would think the creditor would have accepted it because they made so many on-time payments to this company over the years, but they did not. So it was handled, but it took a lot of work because of that goodwill letter. But the point I was trying to make was the more responsible you are, the more you're penalized. That's insane, but that's how our system works. So how long can these negative marks legally stay on your report? Late payments and most delinquencies are measured from the original date of the date of first delinquency, not the date you paid. So every negative mark on your report, this includes charge-offs, are marked from the date that you were first delinquent. That means your first 30-day late is marked from that date. All right. Not the date you made the payment to try to cure the issue, and not the date you opened the account, but it's marked from that specific date. All right. So collections and charge-offs, the clock starts at 180 days after the delinquency that led to the action. And for bankruptcy, it's up to 10 years. And the best way to explain Metro 2 compliance is it's the hidden language of credit reports, and it's the format that furnishers must follow and where it breaks. So I want to put that in layman's terms so everybody can understand it. Right now, we're filming at our office in the Philippines, right? Now, in the Philippines, they speak English, but they also speak Tagalog. So what Metro 2 is the Tagalog of the credit of the Experience Transient Equifax and the furnishers. It's almost a secret language that they speak to each other. And if you understand it, you can use it to exploit them. If you don't understand it, things in your credit report will just look like a foreign language. So you don't have to master Metro 2 compliance. I wouldn't even tell you that. But you do want to know a little bit about it so you actually know what's going on your report. All right. So what Metro 2 actually is. It's a standardized electric format every furnisher uses to report your accounts to the bureaus. Let's break that down. So you have thousands of furnishers. You have American Express. These are just well-known ones. Capital One, Discover, Bank of America, Wells Fargo. If all of them had their own reporting format, that will cause a huge issue in the credit reporting world because they might even report anything, which they do. But for the most part, you have to find a way to standardize that so the consumer can understand, so the CRAs can understand, and so there's a uniform platform in which things are reported. So essentially what Metro 2 does is just uniforms the reporting standards. So it makes sense to everybody, right? And it's maintained by the CDIA, the Credit Bureaus Trade Association. It's updated annually. So a lot of people use Metro 2 compliance in their disputes, but they're using outdated information in their Metro 2 disputes because this thing updates annually. So you want to stay on top of what's going on, and just asking AI is not going to find it. You should actually go to the CDIA website and look it up for yourself to see. Now you can take that document, that annual document from CDIA, and drop it in AI, but just asking AI to find it, it normally won't work. You want to take it, drop it in AI, and see what the updated compliance is for CDIA. So here's some free game that you can use. Go to CDIA, the website, get the updated annual Metro 2 compliance document. It's normally in PDF format. Drop it in AI, and then drop your credit report in there and tell the AI to draft your dispute based on the updated Metro 2 compliance. And that'll give you a better dispute. All right. Number 3, Metro 2 offer also covers each account is a structured record. It comes with the balance, the status, dates, history, with required fields for each one. Metro 2 covers this, right? So furnishers typically report monthly. Every field is a place and an error can live or be challenged. So account status, this is a place or a field that the account can be challenged. Payment history, this is a place or a field the account can be challenged. Date of first delinquency, in my opinion, which is the most important one, that's my opinion. This is a place or field where the account can be challenged. Date open, reported, and closed. Another one. So you have balance and past due amounts. You have all of these fields where you can find a violation and challenge this late payment or this account. But everything on your report, anything negative, the reason why we're covering late payments first on the Pseudomall podcast is because everything on your report that's negative almost always starts with a late payment. So if you can find an issue with the payment, you can beat every other part of the account. The most important date, in my opinion, on any credit report, if we're talking about a negative account, remember I said it always starts the first late payment. So that means it also, what I'm essentially saying is the most important thing you should monitor is the date of first delinquency. If something is off with that, then you have proof, all the proof you need to prove the account, it has been re-aged, right? Now, what's the definition of a date of first delinquency? The date of first delinquency is the first time you were 30 days late and never brought the account back current before the next negative action. So that's the first 30-day late payment. All right. Number 1, it is impossible for the date of first delinquency to move, especially if the account charged off. Right. Number 2, there are differing opinions on this in differing case laws. Me personally, I go with the opinion that the date of first delinquency survives the sale. What that means is if this account was late, then it charged off, and then they sold it to portfolio recovery, it should still have the same date of first delinquency. Now, it does now have a new open date. So now if American Express charges off and they sold it to portfolio recovery, if American Express's open date was June 1st of 1995 and portfolio recovery purchased it June of 2026, they can report that as the new open date. There have been case laws that have stated that, so I will not refute that. But the date of first delinquency survives that. Legally, every furnisher has to report the date of first delinquency. And the date of first delinquency has to be reported within 90 days of placing an account for collection or charge-off. A lot of people don't know that. But now, if they don't report that, which a lot of times they don't, within 90 days, that's why you have to monitor your report. Guess what? You have a violation. And one violation is all you need to get from up under any creditor. Reaging, this all falls under the first part of the presentation or podcast. This all falls under this late payments, right? Reaging. And what they do is, a lot of companies, because most people don't monitor their late payments, don't monitor the date of first delinquency, don't go through their statements and everything and do the math themselves. A lot of these companies do something called reaging. What reaging does is it resets the clock to keep you down. Now, here's why it's so hard. But remember I told you, the first late payment is the most damaging. So what about when they keep resetting that because they know you're not paying attention? Or, I'm going to tell you something most people don't know. Just because they're billion-dollar companies don't mean they have the most up-to-date software. Most of them don't. So because they're following Metro 2 format, a lot of times their software, they don't have the software to report the next month. So that's why you're looking at a report and you'll see 30, 30, 30. A lot of them don't have the software to report 30, 60. All right. So what they're doing is they're reaging. If you have back-to-back 30-day late payments and you did not make payments within those times, they're reaging that, and that's a humongous violation. What is reaging? It's reporting a newer date of first delinquency than the real one, making the old debt look recent. And the effect that it has is the 7-year fall-off date if you don't dispute it or find a violation gets pushed back. So it keeps the mark on your report longer than the law allows. And it's common when debts are sold and a collector stamps the purchase date as the date of first delinquency. So an example of that would be Midland Funding will buy a debt from Capital One, which is very normal. And the date of first delinquency could have been 2 years ago. Midland Funding will mark the date they purchased it as the date of first delinquency, which is a huge violation. So here's how you catch it. You should never just have one credit report you're looking at, right? You should be carrying the data, comparing the data first delinquency across all 3 CRAs, Experian, TransUnion, and Equifax, and now you can even add a Novus into the bunch. They should all match the same exact original delinquency. So you should always watch for the collector's date of first delinquency, that equals the date they brought the debt. So whatever, and you have to be notified of when that debt was sold. You get something in the mail. You match that date to what you actually have record of, right? Watch for a paid then late pattern that restarts the clock without a real cure. And if the dates don't line up, that's an inaccuracy you can dispute and potentially sue over. So I'm gonna give y'all some game that attorneys look for, right? So these are accuracy gaps that attorneys look for first. And if they don't see this, normally an attorney won't take your case. Number 1, inconsistent dates. The dates don't add up, all right? Date open or status dates that differ across all 3 bureaus. A lot of people don't know to look at a status date or date of last update date on a report. This is something that we've won a bunch of cases over. Something as simple as that, all right? Status versus balance mismatch. So somebody put in a current status, but it's past due, or charge-off still showing a balance owed, all right? When we go over charge-offs in the next episode, I'll better break that down. But I want you to remember this. All right, next, duplicate reporting. The same debt listed by the original creditor and the collector as owed, all right? Wrong late marks. A 30, 60, 90 reported in a month you actually paid on time. So in this instance, you have to check your records. Re-age dates. A delinquency date that's newer than your real first missed payment. And reinserted items. A deleted item that returns without the required 5-day notice. That's something the 5-day notice, something will go on in a later episode. But it's just something I want you to remember as far as late payments as well, because sometimes a company might not remove the whole account. They'll remove the late payment and then they'll put it back without notifying you. So that's something you want to keep a record of. All right. Now, segment number 3 in the same episode. Now we're going to look at your FCRA dispute rights, the timelines you have, the golden rules, and the requests that furnishers hate or dread that they hope you never ever find out. You're going to find out in this episode. So here's the dispute timeline that the CRAs must follow. Number 1, the 5 business days. The bureaus must forward your dispute to the furnishers within 5 business days of receiving it. So that's your first timeline. You have to remember the 5 business days. As soon as you send that dispute, the date that they receive it, not the date you send it, the date they receive it, they have 5 business days to forward. If they don't, it's a violation. And I'm going to tell y'all later how to find out if it's actually been forwarded, because a lot of times you'll dispute something. Experian, TransUnion, and Equifax will verify without never having forwarded it to the furnisher, which happens a lot. Second thing you have to remember, 30 days. The CRAs must complete a reasonable investigation within 30 days free of charge. They are allowed, this is number 3, they are allowed a 15-day extension only if you sent new relevant information during the 30 days. So here's what I mean. If you disputed it and they start conducting their investigation and you find some new information that'll help further prove what you're saying, that this account is reporting accurately, you send that in, they have a 15-day, now they can add 15 more days onto their investigation. But they can only do that if you sent new relevant information, all right? Now, here's the beauty of that. If they miss any of the deadlines you just talked about, that's an automatic deletion. But most time they don't delete it, but legally they're supposed to delete it. If they don't, you have to keep record of that, because it's going to help you when you decide to sue them later. Here's the second golden rule. Anytime you have a late payment, never, ever, ever dispute it with the furnisher first. Never dispute it with Discover first. Never dispute it with Amex first. Never dispute it with Citibank first. It always has to be disputed through the CRAs first. It gives you more power and more leverage, and preserves, preserves your rights. You don't have a private right of action if you dispute it with the furnisher first, but you do have a private right of action if you dispute it with the CRAs first. All right. This is under 1681S/2B of the Fair Credit Reporting Act, right? So disputing through the CRAs triggers the furnisher's duty to investigate. And this is privately enforceable, meaning you and I can enforce that without an attorney. It's private. You have a private right of action under that. Number 2, When you do that and you follow the correct procedures, you can actually sue the furnisher for them failing to conduct the proper investigation. So the bottom line is the Bureau's dispute is what preserves your right to sue. So disputing it with Experian, TransUnion, Equifax, and now Innovis preserves your rights to sue as a consumer. But now if you dispute it directly with them, you no longer have a private right of action. So here's the furnisher's real duty after a Bureau dispute. Number one, remember, the furnisher is the person reporting it. A lot of people get this mixed up. I think the furnisher Experian, TransUnion, Equifax. They are not. The furnishers is Capital One, portfolio recovery, Midland funding. These are your furnishers. Yeah, here's their duty after you dispute something with Experian, TransUnion, Equifax. Number one, even though this is on YouTube and all these other platforms, I still want you to take notes so you can remember. Number one, they have to investigate. The furnisher has to investigate. Once Experian, TransUnion, Equifax sends them that notice of dispute or that ACDV record, they have to investigate. They have to conduct its own independent investigation. Right? They cannot just rely on what their internal records. They have to actually investigate, not a rubber stamp. Number two, they have to review everything you sent off. Number three, they have to report your results to the CRAs. And number four, they have to correct or delete it. Here's the reality behind your dispute. There's a system called eOscar, and eOscar is not set up for realistic and fair and reasonable investigations. eOscar is set up for automated investigations. So here's how the pipeline works. You dispute it through Experian, TransUnion, Equifax, or Innovis. They send what's called a ACDV record with a 3-digit code to the CRA. So there's no way your whole page dispute can be summarized in a 3-digit code. But here's the real trick behind that. The system they use to scan your dispute, that system just looks for little keywords in your letter and generates a 3-digit code based on that. So even if you use the word identity, but you didn't claim identity theft, they will send the furnisher an HTTP record that says identity theft. And so the furnisher will conduct an identity theft investigation, which is totally different from a factual dispute. And they'll say it's verified based on that. So your big dispute is just condensed into a 3-digit code. The furnisher doesn't actually review what you sent. It just reviews the code, confirms the update, and then sends it back to the CRA, and the CRA forwards that to you. And the CRA during that time doesn't even conduct the investigation. They just normally go off whatever the furnisher says. Here's your second step. So if something comes back verified, you want to request your method of verification from the CRA. And they have 15 days to provide that. This is how you trap them as well. And then at this point, you can decide whether you want to sue the furnisher or the CRA. In this particular case, if you're requesting a method of verification, what you should always do, it's the easiest trap for the CRA to get not just your late payments, but any accounts removed, because they have to disclose the procedure they use. So this means they have to tell you the description, how they determine the item was accurate and complete. They have to, number two, tell you the furnisher's identity, business name, and address of any furnisher they contacted. And then they have to give you the furnisher's phone number, if reasonably available. They're not going to provide that. They're going to come back with the same response to before, which means verify, and that's proof of a rubber-stamped investigation. Reasonable is a word that I'm going to define because reasonable means more than just a rubber stamp. Right? And one of the case files I'm going to cite is Cushman versus TransUnion, which happened in 1997. Bureaus must do a reasonable, independent investigation, not just verify with the source. Meaning when they dispute, they can't just take Amex's word for it. They have to conduct their own independent investigation. So a reasonable investigation, what courts in the CFPB require, is a reasonable investigation. They cannot merely confirm the data already on file. Bureaus can't just parrot the furnisher's information. They must investigate and weigh what you submit. Number three, furnishers must look past their own computer screen when disputes calls for it. And the CFPB has warned that both bureaus and furnishers, that automated conclusive verifications always fall short. So most of the disputes you sent off, they just conclude them based on whatever they already saw on the computer. They conduct neither one of them. The furnisher nor the CRA almost never conduct reasonable, fair, and accurate investigation. So normally what you see is inaccurate, incomplete, and unverifiable dispute processes. So if dispute information is inaccurate, incomplete, or cannot be verified, the Bureau must promptly delete or modify it, which they do not because they make so much money off of you having bad credit. So why is this your leverage? You never have to prove, right, the item is wrong. The burden is on the furnisher to verify it's right with a real investigation. If the time allowed, if they can't, it comes off, which they never can because they don't invest in the systems to do this. Now I'm gonna tell you why. These are businesses first. So they're all about their bottom line. it's going to cost a lot of money to conduct real investigations, because essentially you have to get attorneys involved. You have to get Americans involved, which they don't do. They outsource everything. And they only want to pay for attorneys when they're sued. They don't want to pay for attorneys during the dispute process, which essentially, in my opinion, they would have to based on how much they have to investigate when something's disputed. All right. So here are the penalties on them with the real teeth, right? You have something called willful versus negligent. So willful under 1681 of the Fair Credit Reporting Act means actual damages or statutory damages 100 up to 1,000 per violation. That's also punitive damages meaning punishment. Whenever you hear punitive, that means punishment with no statutory cap plus costs and reasonable attorney's fees. So the FCRA is what you call a fee shifting statute, meaning if you sue someone or you hire an attorney. I personally do pro se. But if you hire an attorney and they sue them, the company has to cover the fees, the furnisher, especially if you win, you have to cover the fees. That's why it's called a fee shifting statute, right? And so if you can prove something was willful, meaning they just willfully disregarded what you sent, all of your proofs and everything in disputes, they willfully disregarded and rubber stamped the dispute, you now have a willful violation on 1681N. Now, negligent is one of my favorites because you can recover what's called actual damages. So you notice under statutory damages, you're capped at 1,000. Actual damages is not capped, right? You can actually get all the actual things you went through, the emotional distress, the denials you got as a result of this late payment, all of these things, etc. So here's the 3 decisions every credit case turns on, and then I want you to memorize. Safeco versus Burr. Safeco Insurance Company versus Burr. That happened in 2007. TransUnion versus Ramirez. That happened in 2021. And Cushman versus TransUnion, which is one of the most quoted cases in all FCRA cases. And then I'm gonna give you a brief breakdown of each one. In Safeco Insurance versus Burr, what they decided was they defined willful violations include reckless disregard, not just knowing violations. It opens the door for statutory and punitive damages. TransUnion versus Ramirez says to sue in federal court, you need concrete harm. A bare technical violation isn't always enough for standing, which we'll have a much later class about standing. But I think I believe for this particular episode, we needed to start where most negative counts start, which is at the late payment, the first late payment, right? Then you have Cushman versus TransUnion. CRAs must conduct a reasonable, independent investigation, not parrot the furnisher's information. So what they do 90% of the time, actually I say 95% of the time, is whatever Discover said is what they run with, and they don't want to hear anything you have to say about it. So this is why we say sue them all, because the only way they'll listen to you is if you sue them. What the FCRA does not do, so you can stay credible. Accurate marks are unfair. If a late payment is true, reported correctly, the FCRA does not require its removal. That's very true. They do not disputes are for facts. The duty to investigate covers factual inaccuracies, not purely legal arguments about who owes what. So most people go into credit, think, it's not about what's owed. It's about what's being reported accurately or inaccurately. You need real harm to sue. After Ramirez, federal standing requires concrete injury, not just paperwork violations. What I mean by is, if that late payment caused your interest rate on a property you're about to buy to raise by 1%, that's actual damages. If you're being denied apartments, actual damages. If you have higher deposits, these are damages that give you concrete harm. So you have to keep a record of everything. Dispute everything, right? No, that's not the real way, especially for late payments. If you're a person that has 20 late payments on 20 accounts, I say try to do 2 or 3 at a time, because there's no way that everything from everybody is reported wrong. And when you do that, when you go at it that way, it backfires, because all your disputes start getting marked as frivolous, so nothing gets looked at anymore. So you have to play the game. Smarter. All right. Here's the playbook. All right. Number 1, I hope you're taking notes on this. Pull all 3 reports or 4. You can't get a Novus on annual credit report, but you still want to pull all 3 or 4 reports from annualcreditreport.com. Do not come to me saying you pull from Smart Credit. Do not come to me saying you pull from, I forget what the other one is. You only want to use annual credit report or Experian.com. Don't come to me with Credit Karma. Number 2, you need to line up the dates on all 3. You need to check the date of first delinquency, the status, the balance for consistency, flag anything inaccurate, incomplete, or reage. Number 3, You have to dispute through the CRAs in writing with evidence. This triggers the furnisher's duty under 1681S/2B, which is your best friend. I hope y'all read up on that. Number 4, you want to demand the method of verification. If it comes back verified, request that now. They have 15 days to disclose the procedure and the furnisher's contact. Number 5, document everything. Keep a record of why you disputed it, the date you disputed, the tracking number, etc. Number 6, escalate when warranted. If they don't comply and you have proof of non-compliance, you need to be ready to sue them. Now, you can either decide to get an attorney or you can do it yourself. So here's how it goes. Round 1, you're filing a dispute with the Bureau. Round 2, with the Bureau again, you're demanding the method of verification. Round 3, demand letter to the furnisher. I don't believe it in round 4. After that, it's time to sue them all, as you see in the background. After something is verified, your next step is always a method of verification letter to the CRA. And that what returns that reply in the leverage is the fact that I'm telling you they're not going to give you the method of verification. I've never seen one in my life, and I've been in credit since 2016, 2017. It's been 10 years now. I've never seen a complete method of verification letter, and that's how we went out of settlements that y'all see. So here are some myths versus facts. Disputing hurts my score. That's a myth. Paying a charge off deletes it. That's another myth. Goodwill letters always work. That's another credit myth. Pay for delete is a sure thing. It's actually not even legal, and it's another myth. Credit repair firms have secret powers. No, we do not. There are no secret powers. Some of us are just willing to fight a little harder than others, but there are no, and I'm in the credit space, I'm telling you, there are no secret powers. Now, anybody who's claiming that and is doing some kind of secret, normally they're hurting you in the long end, and here's what I mean by that. If you go to method where people use the identity theft and claim you are a victim of sex trafficking and stuff, it'll remove it from your report, but that doesn't absolve you of the debt. So now, when that furnisher decides to sue you for that alleged debt, you lose a lot of leverage because you no longer have something, have the CRAs, which you could have used to, as leverage to beat the loss. You no longer have that because it's no longer reporting. A few violations that you should take away from this call is reaged debts. It goes back to that first late payment. Verified but wrong. Reinsertion without notice. You have real provable harm. You have a mixed file. Sometimes somebody can have the same name as you and you're getting their late payment. You don't know this person is. And so here are 5 takeaways. Number 1, the date of first delinquency controls the clock. Number 2, always dispute through the CRAs. Number 3, unverifiable must come off. Number 4, use the method of verification as your best friend. Number 5, the law has teeth. All right. Here's a little closing out disclaimer. Number 1, if you feel like you're more of a hands-on person, if you look in the description of this YouTube video or wherever you're watching this, I have a free ebook called the Bureau Bully Bible. You can go to the bureaubullybible.com and download it yourself, but I have a free ebook below that you can get. And what you have to know is that this episode is for general education, not legal advice or financial advice, and does not create an attorney-client relationship. Laws and CRA practices change. For your situation, consult a licensed FCRA attorney in your state. Most of the information from this particular episode came from the FCRA itself, which you can look up yourself. It's not a secret. It's a publicly available federal law, 15 U.S.C. 1681. Some of it came from CFPB rulings. Most of it came from case laws like Safeco versus Burr, TransUnion versus Ramirez, Cushman versus TransUnion. And I also look at the CDIA Metro 2 format / FICO / experience scoring data. All of this is readily available data to you and I. So I hope you enjoyed this first episode of the Sue Them All podcast hosted by yours truly, Umar from the Bureau Bullies. You can reach us on Instagram, TikTok, and I hope you get a copy of our free ebook below in the description section. We are out.